You're watching the Legal Breakdown. So, Glenn, we have some major news here. Four members of the Proud Boys, including their leader, Enrique Tarrio, were convicted of seditious conspiracy for plotting to keep Trump in power by leading that violent mob on January 6th. What does this mean for Trump's case that's currently impending before the DOJ?
Well, needless to say, Brian, it's not going to help Trump, and it may end up hurting him for a couple of reasons. So first of all, this is actually a very good day and a very good verdict for the American people, for our democracy, and for the federal prosecutors who brought some very forward-leaning charges, seditious conspiracy charges, which involve basically the attempted violent overthrow of the United States government or a violent attempt to stop the execution of the laws like the Electoral Count Act. And the jury convicted four of the five defendants of that lead charge, seditious conspiracy. The fifth defendant, Dominic Pizzola, he was also convicted of multiple counts and is looking at many years in prison as well. But the four who were convicted of the lead count are facing 20 years in prison just on that one charge alone. And they were all actually convicted of multiple charges in this case. So the Department of Justice can sort of rightly crow a little bit because they have now held the two most dangerous groups that were at the Capitol that day, the Oath Keepers and the Proud Boys, guilty of the most serious charges that they could have brought. What does it mean for Donald Trump? You know, Brian, here is the biggest takeaway that I see. Enrique Tarrio, leader of the Proud Boys, was convicted of multiple counts for the crimes that were committed at the U.S. Capitol on January 6th, and Enrique Tarrio was not there. He didn't set foot on Capitol grounds. He wasn't even in the District of Columbia. Yet because of the conduct of his co-conspirators, the other Proud Boys, he was convicted of crimes that he did not personally participate in. You know what? You know who else wasn't at the Capitol that day? The people in the Willard War Room, like Steve Bannon, Mike Flynn, Roger Stone, Rudy Giuliani, the people in the White House, Mark Meadows, Donald Trump. This case has set what I would call an atmospheric precedent, not a legal precedent, but an atmospheric precedent, because once the Department of Justice succeeds in indicting, trying, and convicting people for what happened at the U.S. Capitol on January 6th, even though they weren't there, that I think is really dangerous territory for Trump and company. So I would tell them all, y'all might want to buckle up, fellas, because your ride, it has just gotten a little bit more bumpy as a result of this verdict.
Now, just as a quick aside, you mentioned that they could be facing up to 20 years for that lead charge. I know that the Oath Keepers have also been convicted of seditious conspiracy, a number of Oath Keepers. Have they been sentenced in their cases yet?
They have not been sentenced. In these big cases, conspiracy cases with multiple defendants, what often happens is the sentencing gets pushed well into the future. Why is that? Two reasons. One, the Federal Probation Office has to do a full background investigation of these defendants and generate what's called a pre-sentence report. That is designed to inform the judge about each defendant who's been convicted and what the judge thinks is the appropriate punishment for each defendant. The other thing that happens is in these big cases, defense attorneys will file what are called post-verdict motions, right? Not appeals, but they'll try to gin up some motions attacking some ruling or another that the judge made and claim that, well, the whole trial was unfair because the judge made one or more mistakes. Let me tell you, those motions are routinely filed. They are almost never granted. But they do take some time to litigate. The good news is these people are all remaining jailed pending sentencing.
Now, I know that we kind of get used to the historic nature of everything that's happening right now, but just to kind of put this into perspective, how unprecedented, how historic is seeing these seditious conspiracy charges passed down?
Yeah, so the seditious conspiracy statute comes from the Civil War era. These charges are rarely brought. I think they were last brought out in Michigan about 10 or 15 years ago, and that case didn't even make it to the jury. The judge ended up dismissing these charges because he didn't believe there was enough evidence to support them. And, I got to tell you, that kind of smarts when you're a prosecutor and you get charges thrown out that you think you have a good faith basis to bring and present to a jury. So, I think the Department of Justice thought long and hard about whether they wanted to bring seditious conspiracy charges, because they could have settled for all of the lesser charges that they did in fact bring in this case, in the Oath Keepers case. Things like obstructing an official proceeding, damaging government property, assaulting police officers, and so on. They brought all those. But, I believe the DOJ felt like, as a matter of principle, they had enough evidence to argue that what the Oath Keepers and what the Proud Boys did was try to violently overthrow our government. They brought those charges and they paid off.
Now, I know that we can kind of maybe look at the Oath Keepers case as kind of a harbinger of things to come in the Proud Boys case that we just have this conviction passed down in. Were the Oath Keepers looking toward appealing the results of this case?
Brian, every single person who is convicted of a felony crime, a significant crime, appeals their conviction. It is a matter of course. One of the reasons is because if you fail or you neglect to file a notice of appeal on behalf of your client, the first thing the client will do is turn around and lodge a complaint against you for ineffective assistance of counsel. So it is routine for all criminal convictions, virtually all criminal convictions, to be appealed. I watched lots of the Oath Keepers trial. I watched some of the Proud Boys trial, including some of the closing arguments. These were well-tried cases. There was a lot of evidence supporting the charges that had been indicted by the grand jury. And I kind of like the Department of Justice's chance on appeal.
Now, we obviously have the seditious conspiracy charges and convictions, Oath Keepers and Proud Boys. Does that make it more likely that Trump himself faces a similar charge? Like, is this basically paving the way for that?
That's a great question, and it probably takes a crystal ball. I don't think that the prosecutors are going to be able to, for example, flip Oath Keepers, flip Proud Boys, and get those folks to directly incriminate Donald Trump. And that's why I say it's more atmospheric precedent. What Merrick Garland and the federal prosecutors have done is they have gone pretty hard, pretty aggressively, and pretty successfully after the boots of the insurrection, the foot soldiers. And Brian, I was in court when one of the defense attorneys for the Proud Boys, in closing argument, said the following: "Ladies and gentlemen, you heard the evidence of Donald Trump saying, 'March to the Capitol, and I'm going to be right there with you.'" Of course, he didn't go to the Capitol, but he said, "Go there, fight like hell, or you won't have a country anymore. Now get down there and stop the steal." In other words, stop the transfer of power. And the defense attorney looked the jurors in the eyes and said, "You know what, ladies and gentlemen, I predict those statements will be government exhibit number 1 in the future criminal trial of the United States of America versus Donald Trump." Rarely do I embrace and applaud something that a defense attorney argues, but you know what? The defense attorney was spot on. And frankly, I think when we look back, that may end up being a pretty prophetic statement.
Well, to that exact point, how does Jack Smith sit in his office watching this case? How does he use any of this information to inform his current case against Donald Trump for inciting the events of January 6th?
So one of the ways he can exploit this evidence is the Proud Boys defended on the claim that, listen, Donald Trump told us to do it. We were just following orders. I happen to agree. Now, mind you, that does not give them a legal defense, because if somebody tells you to do something illegal, it's not a defense that somebody else told you to do it. I would call it a mitigating circumstance, which means maybe some of these folks who attacked the Capitol are worthy of a lesser punishment because they actually thought their vote was stolen, their election was rigged, their president was being unlawfully taken from them, courtesy of Donald Trump's lies. So going back to your question, how might Jack Smith exploit these convictions? One of the things Donald Trump will say about his incendiary speech on the ellipse prior to the Capitol attack is, hey, that was First Amendment protected free speech. Here's the thing. There's a way to defeat a First Amendment free speech claim. The way to do it is if the prosecutors can prove that your speech was, 1, reasonably likely to incite imminent violence, and 2, intended to incite imminent violence. The fact that these Proud Boys in open court defended on Donald Trump told us to do it, and that's why we did it. Well, that knocks down one of the prongs of the First Amendment free speech protection.
Well, and the other, for example, is when he was told by his own staff, his own security, that there were mags there to prevent people from coming in with weapons, and he said, "Let them in anyway. They're not here to hurt me."
Yeah, he said, "Let them in anyway. They're not here to hurt me, and then we can all march to the Capitol." You know what, Brian? That may actually tick up a charge to treason, but we can talk about that another day. But I think Jack Smith can get some mileage out of some of the evidence that was developed during both the Oath Keepers trial and the Proud Boys trial. And there's one thing I'm pretty confident of. Jack Smith and his prosecutorial team have their eyes on everything, and they're presenting to the grand jury what they believe is relevant evidence and information.
Great. Well, we'll leave it there. Obviously, a lot to continue watching for in this case, among a raft of others. So if you want to keep on top of legal news, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown. You're watching The Legal Breakdown. So, Glenn, the Supreme Court has just ruled 9-0 against removing Donald Trump from the ballot in accordance with Section 3 of the 14th Amendment. What was the reasoning behind this?
So the reasoning is that the 14th Amendment, Section 3, says that if you took an oath previously to support the Constitution and you engage in insurrection, you are disqualified. But Section 5 of the 14th Amendment says basically only Congress can make that decision. They can pass legislation that implements the disqualification. So plain and simple, the Supreme Court said the states can't do it, even if somebody is an adjudicated insurrectionist, as Donald Trump is in the courts of Colorado, doesn't matter. Only Congress can pass legislation setting out how it is one goes about disqualifying an insurrectionist, and they haven't done it, so here we are.
Well, help me understand this, because isn't it already clear in the plain text of the Constitution what needs to be done? Like isn't that part already laid out? Why does the court need Congress to tell it how to enforce the Constitution if it's already plain as day?
One thing I can promise you, Brian, is I will not be able to help you understand this. As a trial lawyer for 30 years, my juries would look to me like, Prosecutor Kirshner, can you please explain this? And I would often say, I can't explain the inexplicable because, Brian, as you say, the 14th Amendment couldn't be more clear. If you took an oath of office to support and defend the Constitution and you engage in insurrection, and Donald Trump did, we saw it with our own eyes, and courts and secretaries of state have ruled that he did, you are disqualified.
Right.
So I can't explain how it is. The Supreme Court said, no. There's far more to it than that. Well, there actually shouldn't be. The reason I say there shouldn't be is because the Constitution disqualifies people for other reasons. You're not yet 35 years old. You're not a natural-born citizen. You're not a resident of the United States for 14 years. You have held the office of the presidency twice previously. You're disqualified. And the 14th Amendment, Section 3, speaks in clear, direct, unequivocal language, plain English. Donald Trump is disqualified. So how they can say, no, what we're going to need here is for Congress to get together, put a pin in that, and come up with legislation so all of this can be sorted out and applied consistently, not a state-by-state basis. Now, Brian, I am not all that comforted that the Supreme Court just told us all that this decision, whether to disqualify an insurrectionist from retaking the reins of federal power, we're going to leave it up to folks like Jim Jordan and James Comer and Matt Gaetz and Marjorie Taylor Greene and the other House Republicans to work on legislation and then ultimately to vote that, Donald Trump is an insurrectionist, so he certainly can't be president again. That's especially challenging when Congress is full of insurrectionists. They would be voting against their own interests, both specifically and atmospherically, if they passed legislation implementing the disqualification. This, unfortunately, Brian, I say this with no glee. I don't say it casually. I don't say it cavalierly. We are a failed government in some of the arenas that success matters most. We're not succeeding. We're not capable of succeeding. And I think this unanimous Supreme Court opinion, 9-0. Now, there are some dissents where they call Donald Trump out as being a stone cold insurrectionist, but it was 9-0 on the decision that only Congress can do it, and they have to get to work and pass some legislation to make it a reality, which we all know will not happen. A 9-0 decision means it's the law of the land, right? Whether it's right or wrong doesn't really matter. It's the unanimous law of the land and a unanimous interpretation of the Constitution, and we are stuck with it. There is no appeal from a Supreme Court ruling. Where does that leave us, Brian? We both know where it leaves us. Our viewers know where it leaves us. The rule of law won't save us. The courts won't save us. Congress won't save us. We will save us by getting to the polls in November in numbers too big to rig and too real to steal. We are the only ones who can save us. We did it in 2020. We're going to do it again in November 2024.
Perfectly put. Glenn, to your earlier point about the fact that this is a 9-0 unanimous decision, what was your reaction to seeing that the liberal justices signed on to this?
You know, it makes it clear to me that they all agreed with the constitutional interpretation. And, you know, when you read the Constitution and when you read all of the provisions of the 14th Amendment, I can see their rationale. But when they interpret the Constitution in a way that will sort of clear the path for an adjudicated insurrectionist to retake the reins of federal power, something seems to be off. You know, they could have interpreted the Constitution in other ways, but the reality is when you get 9 justices, you know, left, right, and center, to the extent there are any in the center these days, who all agree that no, this is the best, most appropriate interpretation of the Constitution's disqualification clause and the procedures necessary to disqualify a candidate for federal office. You know, we're stuck with that. And I don't even know that I disagree with the rationale when you read through the opinion and the dissents. I disagree with the result. You know, this sort of blind following of certain words and provisions, if it produces an absurd result, indeed a democracy-ending result, a result that may give the reins of federal power back to an avowed day one dictator, it feels like something's off.
To that point, is the court basically saying that if a 14-year-old came before them and said that I should be allowed to run for president, and without a law on the books, that the Supreme Court would then say, yep, I guess you can run for president. If there's no specific law saying that you can't, you're all good to go. Like, we can't, our hands are tied. We can't do anything about it. We can't enforce the provision of the Constitution that says you have to be 35 years old to run for president.
No, I think it's because the disqualification clause is found in the 14th Amendment, which was an amendment designed to basically prohibit the states from doing certain things. You know, I teach the 14th Amendment to my undergraduate criminal justice students at George Washington University. And the 14th Amendment, what it did was it incorporated a whole bunch of rights in the Bill of Rights, the first 10 amendments to the Constitution, like a right to a jury trial, a right to effective assistance of counsel, a right against self-incrimination, a right prohibiting cruel and unusual punishment, etc. And it imported or incorporated all of those prohibitions into the state criminal justice systems. That's just one example. The 14th Amendment was designed to limit some of what the states could do if it ended up violating the federal Constitution. And so they took that rationale that, wait a minute, the 14th Amendment was not bestowing rights on the states for the first time to, for example, disqualify insurrectionists from holding federal office. And they were careful to say they can still disqualify insurrectionists from holding state office, but Congress is going to have to take up the question of if and how to disqualify candidates from federal office. So they had a number of different rationales. as to why the 14th Amendment, Section 3 was just not the vehicle to give this right over to the states.
So is this basically an admission that as of right now, and until such time as Congress actually passes a law to be able to enforce the 14th Amendment, that the 14th Amendment is basically null and void at the moment? That Section 3 of the 14th Amendment, barring insurrectionists who've held federal office before from running again, or those who've given aid or comfort to those who've engaged in insurrection, that amendment is basically just null and void for the moment?
That section of the 14th Amendment is null and void unless Congress gets off its duff, works together in a cooperative fashion, immediately passes legislation, and then implements it against who? Donald Trump, the leading candidate for the Republican nomination. So I'm going to stick with your formulation that, yes, in the real world, in Washington, D.C., disqualification is dead.
Okay, well, of course, we still have the immunity case that we were looking forward to. Even if, the result of this case is disappointing, I think it is not entirely unsurprising given the composition of this court. But now all eyes turn to the Supreme Court for this immunity case. And again, we have that to look forward to on April 22nd, which yet again was another gift to Donald Trump. So to your earlier point, you and I have spoken about this before, and I think it's worth reiterating because I don't want people to leave this with a sense of hopelessness or despair, but it was never going to be on the courts to swoop in and save us. It was never going to be on lawyers or members of Congress or state parties to swoop in and save us. It has always been our responsibility to figure out how to win this election. And so to Glenn's point before, it's our job to show up as we head toward November and make sure that Donald Trump doesn't win, and to not leave all of that responsibility in the hands of lawyers or judges.
Brian, let's leave everybody with a little bit of silver lining lurking behind the big dark orange cloud that is Donald Trump. As you say, the Supreme Court will take up the presidential immunity claim. Donald Trump says he can commit all the crimes he wants against the American people and never be held accountable, never be prosecuted for it. The broad consensus is the Supreme Court will not buy into the president is king argument, and they will reject that claim and return the case to Judge Chutkan so she can put it back on the trial track in D.C. That's his federal prosecution for trying to overturn the 2020 presidential election. Now, we won't believe it until we see that opinion, in our hot little hands. But the overwhelming consensus is that they were going to let Donald Trump stay on the ballots, but they were also going to let the federal government prosecute Donald Trump for his crimes. That will be the next important sort of benchmark as to whether we have any hope of remaining a viable democracy. So today we took a hit, but I don't want people to think this was the end game, the ninth inning, and everybody's heading into the dugout and we're done. We are far from done because we have another important legal opinion coming from the Supreme Court that we believe will fall our way. When I say our way, democracy's way and justice's way. And then, as we will say probably over and over and over again until November 5th, we are going to fix this problem at the polls. We can, and I believe we will.
We'll leave it there. For everybody watching, if you want to follow along with all of these cases that Trump is contending with and that the Supreme Court is dealing with right now, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.